Welcome to Law and Life. I'm Shashank Mishra as a host, present with renowned senior advocate of Supreme Court of India, Subodh Markandeji. This video is continuation of last video. To learn more about fourth Chief Justice of India and his personality, you can watch the last video, link of which will be given in the description box. In this, we will discuss India's first great dissenting judgment by Justice P.K. Mukherjee. My first question on this, you have called India's fourth Chief Justice B.K. Mukherjee a great dissenter. Which of his first dissenting judgment?
So let me give the facts of this case. This is Dr. N.B. Khare versus State of Delhi. Uh, the incident took place, within matter of 2 months from the inauguration of the Constitution, that is in March 1950. And the case is reported in AIR 1950 Supreme Court. I think page is 211, if I'm not wrong. So what happened that Dr. Narayan Bhaskar Khare was a political activist, and uh, he was deadly against an agreement which was being arrived at between the prime ministers of India and Pakistan, that is Mr. Jawaharlal Nehru and Mr. Liaquat Ali Khan. So having come to know about this, that he may hold an agitation, uh, the uh, what happened that I think he was to hold some demonstration or hold a rally or something opposing the Nehru Liaquat Pact. He was specially concerned about the raw deal to the Buddhist and Hindu refugees from East Pakistan, that is now Bangladesh. While camping in Delhi in this connection, he was served with an order of externment dated 31st March 1950, passed by the District Magistrate of Delhi under Section 4 of the East Punjab Public Safety Act 1949, directing Dr. Khare to remove himself from Delhi. So, Dr. Khare filed a writ petition under Article 32 of the Constitution and challenged the district magistrate's order as violative of his fundamental rights guaranteed to him by Article 19(1)(d) of the Constitution. His writ petition was heard by a five-judge bench consisting of Chief Justice of India, Harilal J. Kania, and Justices Syed Fazal Ali, M. Patanjali Shastri, Meherchand Mahajan, and B.K. Mukherjee. Now, four judges held that the judicial review by the Supreme Court under Article 32 extends both over the substantive as well as the procedural aspects of law. Justice M. Patanjali Shastri held that the question does not arise, so he did not express any opinion. Three judges, that is Chief Justice of India, Syed Fazal Ali and Patanjali Shastri, held that the impugned order did not infringe Article 19(1)(d) and dismissed the writ petition. Justice Mukherjee, with whom Justice Mahajan concurred, held that Article 19(1)(d) was indeed violated and therefore allowed the writ petition. So now let us look at the reasoning. So dissenting judgment of Justice Mukherjee, with whom Justice Meherchand Mahajan concurred, is remarkable for its brevity. It's a very small judgment and calibration and simplicity. That's the beauty of it. It starts by describing the substantial contention raised by the petitioner, namely that when the Constitution came into force on 26th of January 1950, the East Bengal Public Safety Act 1949, under which the DM purported to make the externment order, became void and inoperative by reason of its inconsistency with the fundamental right guaranteed to Dr. Khare under Article 19(1)(d), and this inconsistency is not saved by Clause 5 of Article 19, and any order made by such a void law must necessarily be void and of no effect. So, in that connection, the judge considered sections 4(1), 4(3), and 4(6) of that law and articles 19(1)(d) and 5, and proceeded logically to hold that the reasonableness has to be determined by the court. If the court holds restriction to be reasonable, the petitioner has no remedy. If, on the other hand, restriction is held by the court not to be reasonable, Article 13(1) of the Constitution imposes a duty upon the court to pronounce the law to be invalid to the extent of its inconsistency. So it's a step by step, very logical judgment and very brief. The learned judge then considered the contention of the Attorney General for India, the great MC Settlewad, that Article 19(1)(d) should be given a restricted interpretation. It contemplates only absence of interstate restriction, preventing the citizen from moving from one state to another, and rejected that contention as unwarranted on the plain language of Article 19(1)(d). The Honorable Judge went on to hold that what Article 19(1)(d) guarantees is free right to all citizens to go wherever they like within the territory of India without any restriction whatsoever. So I'll give a small quote. They can move not merely from one state to another, but also from one place to another within the same state. What the Constitution lays stress upon is that the entire Indian territory is one unit so far as the citizens are concerned. So that's the quotation. He agreed with the Attorney General that adjective reasonable in Clause 5 governs the restrictions which are imposed by law and not on the law by itself. But he held that that does not mean that in deciding the reasonableness or otherwise of the restriction, court has to confine itself to examine the restriction in the abstract without any reference to their duration or territorial extent, and that it is beyond the province of court to look into the circumstances under which the restrictions had been imposed. Any law which places the liberty of a citizen at the mercy of an executive officer, howsoever highly placed he may be, and whose action cannot be reviewed by the judicial tribunal, is by itself arbitrary and not a reasonable exercise of legislative power. He reasoned that Section 4(1)(c) of East Punjab Public Safety Act is not unreasonable merely because the order can be passed thereunder by the provincial government or the district magistrate on their personal capacity and not on the material which satisfies certain objective criteria. But the position would be different if the order that they passed is allowed to continue for an indefinite period without giving the aggrieved person any opportunity to say what he wanted to say against the order. So, very step by step and very logical. According to this judgment, Section 4(3) of the East Punjab Public Safety Act places no limit on the period of time during which an externment order would remain in force if the order is made by the provincial government. Just see, indefinite, which has been uh, given unlimited authority in this respect. And they can keep the order in force as long as they choose to. Uh, Even as regards the order passed by the district magistrate, the honorable judge held that the period of subsistence of the order has been restricted to 3 months, but the provincial government is competent to extend it to any length of time by a special order. So the law, which does not fix any maximum period beyond which the order cannot continue, is unreasonable. The fact that Act itself expires on 31st August 1951 is not relevant at all. Provisions of Section 4.3 are therefore manifestly unreasonable and cannot be supported by any just ground. When orders are to continue indefinitely, it is only fair that opportunity should be given to the person against whom such an order is passed, and they must have the opportunity to say what they want to say. As regards Section 4.6 of this Act, the Honorable Judge held that it makes it entirely optional for, with the authorities to communicate the grounds upon which the order is made or not. Grounds need not be communicated at all if the authorities so desire. Further, the latter part of Section 4.6 seems to imply that when an order is to remain in force for more than 3 months, right of representation should be given to the aggrieved party, which should be referred for consideration to an advisory tribunal under Section 3.4. The right is, however, totally illusory. Even when the order is to be in operation for more than 3 months, there is no obligation to communicate to the person the grounds on which the order is made against him. And it will be impossible for him to make any adequate or proper representation if he is not told the grounds on which the order is made. Thus, subsection 3 is not uh, thus not only subsection 3 but subsection 6 can be ever held to have imposed restrictions that are either reasonable or in the interest of general public. Consequently, under Article 13(1) of the Constitution, the provisions of Section 4.3 and for Section 4.6 of the East Punjab Public Safety Act became void, and the order made by the district magistrate cannot stand. Justice Mukherjea therefore allowed the writ petition and quashed the externment order. This dissenting judgment of Justice B.K. Mukherjea was seminal and has inspired several thought-provoking judicial interventions later. And this is the first great dissent under the Indian Constitution.
Sir, how did that case arose?
Will you kindly repeat the question?
Sir, how did that case arose?
That case arose uh, because Dr. N.B. Khare wanted to hold a demonstration against the uh, against the agreement which was envisaged between the prime ministers of India and Pakistan, and that order under Punjab Public Safety Act was passed to extern Dr. Khare from Delhi.